Welcome to the deep dive.
Good to be here.
Today, we're getting into something quite specific but really interesting, where land acquisition bumps up against tax law.
That's right. We've got this High Court of Karnataka order. It's about GST.
GST, yeah. And specifically whether it should apply to something called Solatium when land is, well, acquired by the government.
Exactly. The core issue, really, is why this tax was challenged in the first place.
Okay, so let's set the scene. Who was involved?
We had the petitioners, Asha and others, versus the tax authorities, the Assistant Commissioner of Commercial Taxes and others.
Got it. And the big question was, should GST be levied on Solatium? The petitioners were saying no, right?
Precisely. Their argument was basically that Solatium isn't a payment for goods or services. It's not like a normal transaction.
And it's also not payment for agreeing to tolerate something, which is apparently a key point in GST law sometimes.
That's a crucial part of their argument, yeah.
Okay, before we dive deeper into the arguments, let's clarify what is Solatium. The sources imply it, but maybe we can spell it out.
Sure. So in land acquisition, you get compensation for the land value itself. Solatium is, well, it's an additional amount on top of that.
Like an extra payment.
Yeah. It's generally understood as compensation for the compulsory nature of the acquisition. Think of it as acknowledging the distress, the inconvenience, the sort of emotional hit of losing your property unwillingly.
Right. It's not just the market value. It's for the compulsion aspect.
Yeah.
Makes sense.
And that definition is really central to why Asha R and the others fought the GST charge.
How so?
Well, they argued, look, the Solatium payment, it's fundamentally tied to the land value. It's part of the compensation package for the land.
Okay.
It's not a separate fee for some service we provided or for goods we sold.
And definitely not for agreeing to the acquisition because, well, it's compulsory. You don't really agree in the normal sense.
Exactly. They weren't entering into a contract to have their land taken. The law allows the government to take it.
So the payment isn't for tolerating the act, it's compensation because the act happened. That's the distinction they were drawing.
That's the gist of it. And, under GST, tax usually applies when there's a supply of goods or a supply of services.
Which usually involves some kind of agreement or transaction, right?
Typically, yes. So the petitioners are saying this situation, it just doesn't fit that mold. Solatium isn't part of a taxable supply.
Okay. That seems pretty logical. So how did the High Court of Karnataka see it? What was the outcome?
The court actually agreed with the petitioners. They sided with Asha R.
Really? So they struck down the GST demand?
They did. The court quashed the show cause notices and the orders that tried to levy GST on the Solatium.
Wow. Okay, that's quite significant. What was the core reasoning behind the court's decision?
The court really focused on the nature of Solatium. They explicitly stated that it forms an integral part of the overall compensation for the land. It's not separable, in their view.
So not an independent payment for something else.
Exactly. And crucially, they addressed that tolerating an act point. The court found there was no agreement, no contractual obligation from the landowners to tolerate the acquisition.
Because it was compulsory.
Precisely. Since that element of agreement or obligation was missing, it couldn't be considered a supply in the sense of being paid to tolerate something, which is a specific category that can attract GST in some contexts.
Ah, okay. So that's the aha moment, isn't it?
Mm-hmm.
The court drew a clear line. Compensation for the land, including Solatium, is one thing, and payment for a service or for agreeing to tolerate something is another.
That's the key distinction they made. Solatium falls squarely into the compensation bucket, which isn't generally subject to GST in this context. Land transactions have their own tax rules, like stamp duty, but GST wasn't deemed applicable here.
I see. So this brings quite a bit of clarity, potentially, for anyone going through this process.
Absolutely. It clarifies how this specific, often significant part of the compensation package should be treated for tax purposes. Removes a layer of uncertainty, you could say.
So, for anyone listening, maybe you've had dealings with property rights, or just find tax law fascinating. This case is a great example of how courts interpret these laws when individual rights intersect with government actions like land acquisition.
It really highlights how important definitions are in law. What constitutes compensation? What constitutes a taxable supply? The court had to carefully delineate that.
Okay, so let's quickly wrap this up. The main takeaway from our deep dive today.
The High Court of Karnataka has ruled pretty clearly. GST does not apply to Solatium paid during compulsory land acquisition
And the reason being?
because it's considered an indivisible part of the compensation for the land itself, not a payment for any service, goods, or for tolerating the act of acquisition.
Right. No taxable supply happening there, according to the court.
Exactly.
So this clarifies things for Solatium. But it does make you wonder, doesn't it? What other parts of these big compensation packages and land deals might have their own tricky tax questions lurking?
That's a great point. Things like interest payments on delayed compensation or maybe other specific components, could they face similar scrutiny? Definitely food for thought.
Indeed. Something to keep an eye on. Thanks for breaking that down.
My pleasure.